What's good with it? What's good with it? What's good with it? People. Now you know me. I much rather prefer to read this goddamn indictment. Because we want to know. Because we've been speculating. We want to know if she finna to talk about what y'all said, all this crazy bullshit, or she gonna talk about the facts. I ain't even said hey to y'all, so let me do that. Let me put it on up here to let y'all know it's in. And I think it is accessible to everybody, so I think I'm logged into my regular ID and pacer, so y'all see it. Hold on, wait a minute. Hold on, wait a minute. Oh yeah, okay. Yeah, this her appeal. Wait a minute, I thought I put some wrong shit up here. oh, oh shit. Listen, boy, I be doing too much. Okay. So right here, let me tell you. So you see the petitioner. When it's an appeal, just at the district level, you're always going to be a petitioner. But when you go upward, then he's going to be the appellate. Okay, so right now he is the petitioner. He goes up. If this gets denied or whatever, I'm not saying it is or whatever. I'm just saying then he'll be the appellant. So, what's good with it is what's good. What's good with it? What's good with it? So, let me say hey to you. I want to make sure I got the right shit up here. So that's by Bonjean. This is her perfect brief. And let's see, I'm coming right here and see what y'all are saying. Let me say hi. Hey, Queen Brielle. Hey, Lady Tech. Hey, Shawty. Karen Johnson. What's good? Chanel Lewis. Hey, Haunty. I thought somebody said Karen J was in here. Oh. Hey, Chanel Lewis. Hey, Donovan White. DB Wow Wow. Hey, Danny. Courtney Love. So, the paperwork is here. What y'all want to do? Karen J. Where you at, Karen J? So, let's see. Now, you know I want to read this. So the table of contents is a teaching moment, right? I don't want to say teaching moment. I don't like that. I want to say conversation, right? So, just tell me what y'all want to do. Y'all want to, because I was going to go live anyway, because I'm off. Two, I had stuff to talk about. I was going to talk about the appeal process, which is already here, but we got the actual documents to read. But I was going to talk about some other processes of the appeal process. I was going to talk about uh some other things because I think that hopefully we can move beyond because I cannot stay stagnant in the stationary in the same place going over and over and over and over and over and like I've never said it before. Like when you get to a place like when like in school when you're and I'm not saying I'm trying to teach y'all, I'm just saying when I'm teaching in school, right? Usually they may stumble at the first mark, right? When we go over it several different ways, right? Then they get that, and then we move to the next mark. And then if they stumble, they will, we'll do the same process and get that. They don't usually return back to number one as if they ain't heard the shit before ever, as if it's foreign. Some of y'all do that. And that's gonna drive me crazy. Listen, I want to maintain and retain all my goddamn hair. Whenever they separated, huh? That's what I want to. That's what I want to have, all of it. So that's gonna drive me crazy. So that's why I say y'all gonna have to, understand, read about the FRE, read FRCP. SpongeBob did add in FRAP, but don't worry about that yet. Don't worry about the Federal Rules of Appeals process. Don't worry about that, because you need to get FRE and FRCP down first, because you got questions as to why did this happen, and you're not understanding the justification. You keep wanting to impart either what you think should have happened or some kind of street ideology or whatever, what you think should have happened, or what you think the law should be, and all of that. And none of that matters, because that is of no consequence. And the closest I tried to get to it, will the attorneys take what you think into that courthouse and use it as a defense? The closest thing that they have done with regards to that would be that BOP stuff. But in my opinion, I feel like it was a R. Kelly engineered motion, right? As a lot of motions are for all claims, not just him, for all claims. They especially they hear something in jail, or they uh have a problem with something that happened in the courtroom, or it was a piece of evidence, some whatever, and they would ask the lawyer, can they draft up a motion contesting this, contesting that, or whatever. So there's nothing wrong with that. One, they always ask you, especially they don't have a bond, can you submit a motion for a bond? So it is let me write this down real quick. Oh, I forgot, baby. I forgot. Forgot to tell you. No, I forgot. It came in so quick. That I was sitting up here, and it came in so quick. I just went live because I forgot. I'm sorry. No, never that. Um, yeah, and I was also going to talk about some of the message board Q's and A's I have. So, I know I'm so fired. I'm sorry. Girl, I was preoccupied. Trying to listen to different lives and stuff like that about this Don Russell stuff. But now it's here. And I know I asked y'all what y'all want to do. Where's Karen, Karen J? Cause she can be, I done missed the live. No, baby, never that. I forgot. I totally forgot. But anyway, so we'll be able to talk about some stuff. We can start talking about some stuff in this table of contents. All right, so it says, so in her table of contents, this is what she's appealing, right? It says order denying defendant's motion to dismiss and motion to strike dated May 22nd, 2020. So remember I was telling you about on with motions, their objections, right? They're on the record, and throughout the hearing, you may hear an attorney say, preserve the record, right? It's all doing the same thing. So even though she wasn't the attorney of record then, she's going back and appealing that particular whatever happened on May the 22nd, 2020. What was a motion to dismiss and a motion to strike, right? She has a problem with that. It says the memorandum decision and order denying second motion to dismiss the indictment dated October 26, 2021. Okay, I got you. Oh, okay. I hope I'm logged into the right uh the right motherfucking ID. Hold on, cause you talking about you can't get it. Hold on. Hold on, y'all. Let me take this down real quick. Shit. Y'all gonna have me in trouble. Hold on. Okay, let me see. Let me hold on. Hold on, I'm sorry. Hold on. All right, you should have it. Okay, y'all. Let me put it. Oh, where is it? Shit. Uh, okay. All right. So right here, what was on the second one? Second one, you have a, you're welcome. A memorandum decision in order denying the second motion to dismiss the indictment dated October 22nd, 2021. Then you have an order granting in part and denying in part the government's motion in limine dated November 4th, 2021. She had a problem with that. The trial transcript excerpt from Judge and Donnelly ruling on prior bad act evidence from September 14, 2021. So I told you the other live that she probably is going to go after all of the bad act evidence, which is those uncharged acts and maybe some other stuff she dug up, right? So that. Then you have the memorandum decision. So she is going after Ann Donnelly rulings in here. Okay. So she's, yeah. So she's going after the order granting in part and denying the trial transcript excerpt from Judge Ann Donnelly ruling on prior bad acts evidence. You have the memorandum decision and order denying defendant's motion for a judgment of acquittal and a motion of new trial. That's the one she did. Okay. And then you have the memorandum decision and order granting the government's request for a turnover dated dated September 9th, 2022. Is that the BOP shit? Whoa, let's see about that. So that's page 157. I'm so nosy, I want to see it now. It says memorandum decision and order granting restitution dated. Okay, so she got the restitution in there. Amended judgment, the California Health and Safety Code. Now, okay, so I guess she has a problem with, maybe, remember, I think it was an issue whether or not they was using the the wrong California code to apply to this particular case. I think it was, maybe she was saying maybe one had been amended or something like that. It could be that, or it could be when she was told that it should have been a pretrial motion and it wasn't, so it wasn't heard. So maybe she's bringing that up. Maybe that's what it is about these California codes and this New York code. Let me see. But also with this, I'm not going to also read it. I'm going to tell you, maybe, depending on what it is, if it's, what's the chances of it maybe, gets a denied or granted. And if I can tell, because I can't remember everything in the case, but what she have to prove to see, for it to be, a good challenge, right? Did she get everything she need, right? Or did she take the easy way out and just grab up all the motions and put, why she think this shouldn't have, should have been granted, should have been denied or whatever, and just let it fly out the door? Or did she put in a good faith argument behind it to substantiate what she's saying in here? Because remember, this is other people's work. Okay. Her work didn't start till, like, what, after the conviction, right? So she'll be talking about, she's trying to defend other people's work. So look at it as that. And let's get to it. But I got to be nosy real quick. I'm sorry. 157. Is that the BOP shit? Hold on. I'm nosy as far as this. Okay. Wait a minute. Wait a minute. Hold on. It won't let. Oh. Okay. Well, I'm gonna have to. Okay. Well, I'm gonna give it to. I'm gonna get it to you then. I don't know. I think I sent it on the right. I'm gonna give it to you. Okay. This BOP stuff in here is talking about the money they took. Okay. So let me start reading. I don't know what happened because I is it encrypted? Because I'm logged into both things, so maybe it encrypted it. You know, I you know. But I'm gonna send it to you. I'm gonna get it to you. All right, so let me start reading. It says the defendant is awaiting trial on charges of racketeering in violation of 18 U.S.C. sections 1962C and 1963. What? Okay, so she included. All right, so nobody won't get confused. All right. Remember, I said I want to see if she just included the motions and said a little verbiage, but didn't do much, much to make it persuasive, and just send it on out the door. I'm not saying that's what she did, but I do see that. Okay, here's the motion, so you won't get confused because I know this up on the screen. This is the motion dated 5/22/20. So it's included in the appeal, of course. All right. So I don't have to read that because we already know about this motion. I'll tell you what it was about, though. This was the motion. So I'll read enough of it to tell you what it was about. Then we're going to get to her appeals process. That's going to cut down a lot of time. All right. So this was the motion dated 5/22/20. Now, other people might read the entire motions and stuff. That's because they don't know what they're doing. Okay. So it says the defendant is awaiting trial on charges of racketeering in violation of 18 U.S.C. sections 1962C and 1963. 3 counts of Mann Act transportation to engage in illegal sexual activity in violation of 18 U.S.C. section 2421A. 3 counts of Mann Act coercion and enticement to engage in illegal sexual activity in violation of 18 U.S.C. section 2422A. 1 count of Mann Act coercion of a minor to engage in illegal sexual activity in violations of 18 U.S.C. section 2422B, and 1 count of Mann Act transportation of a minor with intent to engage in illegal sexual activity in violation of 18 U.S.C. section 2423A. And that's ECF number 43. So that's the number of this motion in PACER. Currently before the court, all the defendant motions to dismiss the racketeering charge and to strike the allegations that cite section 2307 of the New York Public Health Law. It says the government opposes. For the reasons that follow, the motion are denied. And the background, the third superseding indictment, to charges of racketeering. Okay, the discussion. All right. This was the defense discussion on this motion. This is what their objection was, okay? It said the defendant makes 2 challenges to the third superseding indictment. First, he argues that the racketeering count must be dismissed because the indictment does not allege a legally cognizable enterprise within the meaning of 18 U.S.C. Section 1962C. Okay. Second, he moves to strike the charges that cite Section 2307 of the New York Public Health Law on the theory that the law is facially invalid, overbroad, and vague. Neither claim is persuasive. Motion to dismiss count 1. The dismissal of an indictment is an extraordinary remedy reserved only for extremely limited circumstances implicating fundamental rights. Okay. To withstand a motion to dismiss pursuant to Rule 12, which are pretrial motions, an indictment needs to do little more than to track the language of the statute charged and state the time and place in appropriate terms of the alleged crime. Okay, more case law, more information. I'm going through this because this is the old motion. Okay, I'm just trying to give you a little background what it's about. I don't need to read this old motion. Okay, I don't need to go through the case law. They've already done that. We've already done that. Okay, we're gonna get to the motion to strike. The indictment alleges that the defendant transported one of the victims in interstate commerce, intending that she engage in sexual activity for which a person could be charged with a criminal offense. The indictment identifies two offenses with which the defendant could be charged. Section 2307 of the New York Public Health Law, which makes it a misdemeanor for any person who knowing himself or herself to be infected with an infectious venereal disease has sexual intercourse with another, and section 120.20 of the New York Penal Code Law, reckless endangerment is the second degree, which is recklessly engaging in conduct which creates a substantial risk of serious physical injury to another person, a Class A misdemeanor. The defendant argues that the Racketeering Act and the Mann Act counts that incorporate the violations of Section 2307 must be dismissed because Section 2307 is facially unconstitutional and facially invalid, overbroad, and vague. According to the defendant, the statute is overbroad because it bans people with infectious venereal disease from having consensual sex, and is vague because it fails to define what is meant by sexual intercourse and what is meant by sexually transmittable disease. Even if the defendant were to succeed on his challenge to Section 2307, his motion to dismiss would fail because the indictment also alleges that he could be charged with violating the reckless endangerment statute, the constitutionality of which he does not challenge. In any event, his challenge to Section 2307 is meritless in the context of this case. Okay? So I'm giving you a little background about what it's about. Now I want to get to what her argument is, okay? Because I know she added to this. I'm gonna get to it. So we're talking about the exposure of the herpes. Okay, so that's Ann Donnelly denying that motion back then, right? Okay. All right. The next thing she talked about was the defendant's charge with racketeering. What was this about? Moved to dismiss one of the indictments and the count of indictment incorporating the New York Public Health Code again. So apparently, this was the second motion talking about those herpes, the New York Code. Superseding indictment, return charge of defendant with racketeering. And this defendant has three challenges. Okay, defendant raised three challenges to this. Okay, first, he argued that the PHL Section 2307 and the CPL Section 120.20 charges should have been dismissed on the theory that the government could not prove the elements as a matter of law. The defendant contended that dismissing these charges would make venue inappropriate in the Eastern District of New York and that the indictment should have been dismissed accordingly. So, in this particular one, they're saying that the venue shouldn't have been in New York. All right. Maybe they challenge, maybe could have been that maybe they didn't have sex in New York, or maybe they had it in Chicago, but not New York, or whatever his argument could have been. Usually, when they start talking about venue and things of that nature, has something to do with the where the crime was committed and so on and so forth. So there's different reasons for that, right? And it also could be something dealing with the jurisdiction as well. Do they have the jurisdiction to hear this case? And it's probably yes, because one, this is a criminal case, and if the crime happened in New York, then there'll be again yes. And this happened. This case took place. This trial took place in New York, so that makes sense. Now, and we know she denied it because, of course, that's why we got the appeal. This is Racketeering Acts 12 and 14 count and counts 6 through 9. So I guess all that has to do again with the herpes, because as you see here, the defendant moves to dismiss Racketeering Acts 12 and 14, as well as counts 6 through 9. These counts charge that the defendant violated the Mann Act when he engaged in unprotected sexual intercourse with Jane Doe number 6 without first informing her that he had contracted herpes and obtaining her consent to sexual intercourse in those circumstances, in violation of PHL Section 2307, CPL Section 120.20. So all this is about the herpes. Okay? We don't have to keep going about the herpes. I should have just stuck with the table of contents and went through passed through all of this and got to her argument, which is what I think I'm going to do. So give me a minute. Let me find her argument. Okay. Well, I guess we can go on to part 2 of this live because all it is the emotions. Hmm. Okay. Okay. Let me look at something real quick. Give me a minute. I'm looking at something real quick. Okay. Give me a minute, y'all. Okay. In second Washington. Okay. All right. Let's see what she did. Okay. All right. Okay. For anybody that's doing this, make sure you go to the footnotes because this is where your reading is going to be. All right. Oh, God. 2. All right. Now, I need to advance people today because this is some bullshit. All right. Let me read this. It is not clear that this second motion to dismiss was timely. Okay. The defendant filed it on August 9th, 2021, after prospective jurors completed questionnaires and on the morning that questioning of individual prospective jurors began. Federal Rules of Criminal Procedures, remember I tell you in the FRCP, 12B3 requires certain motions to be raised pre-trial. Motions that fall under 12B3 include claims of improper venue and defects in the indictment. Federal Rules of Criminal Procedure 12B3. Rule 12C3 provides that if a party does not meet the deadline for making a Rule 12B3 motion, the motion is untimely. The defendant's attempt to evade this result by styling his motion as a 12b2. The motion not subject to 12c3 is persuasive. The arguments in this motion, which are discussed in detail in the sections below, clearly fall within 12b3. Nor did the defendant establish a good cause for the tardy filing. Indeed, the defendant moved to dismiss many of the same charges more than a year and a half ago. No, that's from the gone. That's his condition of supervision. Well, this is all we're going to work with. So I can tell you what she's going we're going to go over this again. I can tell you what she's appealing. All right. She's appealing that motion to strike and dismiss. So we know that was about the herpes. Deny the second motion to dismiss indictment. I think that was a herpes and the RICO. The motion in limine. So, damn, this is going to require me to go back in the system. Hold on, y'all. SBA 52. Oh, text messages. Wait a minute. The government moved to admit text messages that Jane Doe number 5 sent to her mother and friends. Because the admissibility of these texts turned on trial testimony, I reserved decision for trial. At trial, the text messages were admitted without objection. So the text messages is in here. But the certain text messages, not all of them. What is her objection to this? SPA 45. Hold on. Is it some more? Hold on for a minute, y'all. Mm. Okay, wait a minute. Hold on. I jumped the gun. Hold on. I was too quick for myself. Hold on. Whew. It's a whole lot more. Hold on. I just went back in the system. It's a whole lot more. Hold on for a minute. They just loaded the last thing at 11:53. It's 11:57 now. Let me come back around there. Where y'all at? Let me come the fuck back around there. Let me wait a minute because they still uploading. Shit, I'm sorry. Hey, they still uploading. My bad. My bad. My bad. It's okay. Lord have mercy. They still uploading, so I don't know what all we gonna get. Let me speak to her. Thank you, Purple Purple. Let me speak to the rest of y'all. Hold on. Let me refresh. Shit, I don't know what the hell's going on with this shit. She is, my God. Baby, honey, let me tell you something. Ain't nobody reading this. I'm gonna tell you how many pages. Ain't nobody gonna discuss this shit. We gonna wait for the outcome. I'm gonna tell you how many pages. Are you fucking? Let me see how many pages. It is 1,442. So okay, so we got that. We have this. Let me see what this is. Okay. She did the okay, the transcripts is in. It's everything is on the record is in here. They uploading the record. Okay. So we got the old school. Hold on. Hold on, y'all. I got to log into. So let me log into. Just hold on for a minute. Shit. Okay. Move this over here. Oh, y'all. Move this over here. Okay. I'm just gonna have to wait a minute. So, where is the... Where is the... Okay. Okay. Okay, so that's... Okay. So... So... She got a problem with... Okay. She's appealing... Okay. She's appealing every count. Okay. Okay. Appealing every count. Okay. And then we do go to... What date is this? I'm old school in it, so y'all just like doing it by hand. Hold on a minute. Okay. She's doing... She's doing November. What date is that? She is... Oh, no. Okay. She is appealing every count, and she's going after Judge Donnelly's ruling on that motion in limine with regards to sexual contact with... Okay, the evidence regarding sexual contact with Jane Doe number 1 as a minor in 1994, sexual contact with Jane Doe number 7 as a minor in 1991, sexual contact with Jane Doe number 8 as a minor in 1994, sexual contact with Jane Doe number 9 as a minor in 1995, exposure of Jane Doe number 11 to a sexually transmitted disease in 2001, sexual contact with Jane Doe number 13 as a minor in 2006, sexual contact with John Doe number 1 as a minor in 2006, threats towards employee number 1 and settlement payment to Jane Doe number 15, So pretty much all of that, those uncharged acts and stuff, and the evidence that went along with it. Threats towards Jane Doe number 6 in 2018 and 2019. Alleged threats to Jane Doe number 19 in 2018. Wait a minute. No, scratch that. Okay, going to the audio recordings of the defendant's physical abuse and threats. The Jane Doe number 5 text messages, employees' text messages, defendants' text messages. She's going after that. Now, this is, when I say going after, this is the judicial determination, right? Remember, I told you, you appeal based on issues with the facts in the case, which is the evidence, the law, what did the judge apply the law correctly, and judicial discretion or abuse or what have you. Did they abuse their power or whatever? So we can talk about certain things. Some newspaper articles. Prior conduct of witnesses. So she's saying the prior conduct of witnesses, like the sex, prior sex with anybody other than the defendant, mental health histories, evidence about the victim's parents. Oh. Okay. Okay, now what's the next one? So she's going after. Hold on. September 14th. Okay, so this one is. I mean, is it about is it the judge or? Oh no, trial transcript. Okay, she's going after the judge about what she said. Hold on. She's going after the judge about what she said. I'm sorry, y'all. This got to be old school. Ooh, wait a minute. So, what did the judge say? So, whatever the judge said, hold on. This shit is crazy. I'm crazy for doing it. Hold on. What did that judge say? When I say the judge say, I mean the judge order. Right? We talk relaxed over here. The judge's order, whatever she said. Hold on. Hold on. Man, if I just okay. So wait a minute, is this the whole thing? Okay. So when the judge said, okay, so she's going after this. I'm just gonna read it. I don't know. Okay, Judge said, good morning, everybody. I know we are going to get the witness in a minute. I'm prepared to rule on the motion in limine. I am going to adhere to my decision with respect to the videos. I know that I've received Mr. Scholar's letter on it. I think that the evidence is relevant. So I guess she's going after this. The judge is ruling on this. Says the witnesses have testified to the almost constant videotaping of various sexual encounters, and this is obviously relevant to the videotapes involving the sexual encounters. They're obviously relevant. I'm sorry, I think some witnesses have been questioned about whether it's Mr. Kelly who is taping them, and in any event, I think they are relevant, and I adhere to my decision on these videos. With respect to the recordings that the government represents show that the defendant is verbally abusing and threatening someone, I also am going to adhere to my decision that I made before the trial, admitting those recordings. So she's going after those recordings. Those recordings are they they're obviously relevant because they demonstrate the defendant behaving in a way that the witness have described throughout the trial, that he demanded that they adhere to certain rules, and that he directed their activities. So she's going after her particular ruling with regards to the videotapes, right? She's going after her ruling with regards to that. So let me get back in here. What was that? Sorry, y'all. This I got the old schooler. My bad. Hey, I don't know what to tell you. Sorry. We could do fun shit in a minute, but I mean, it is what it is. I mean, am I logged in too many places? Okay, let me go back into this. Like that. Okay. Yeah. Okay. So where is the paperwork? Ah. Okay. She is going after. Okay. So let me look at this one. Damn, this old school as hell. Y'all can see this on the other side. Only you can see it. She is going after. Um. Okay, so she's going after the judge's decision of um of her motion for an acquittal and new trial, right? So, is it the complete thing? So that remember that whole thing, the Curcio. So the judge's entire ruling on the new trial and the acquittal. So everything that was in there, she's going after all of that. Okay. Okay. 150. Okay. What is this? Okay. She's going after Judge Ann's decision about that money. Mr. Kelly want his money back. So when the BOP, when the prosecutors instructed the BOP that to see to seize his bank account from the jail, she's going after that money. So we already knew that, but that's in here too. Okay, she's going after that. Let me see what this is real quick. Okay. She is going after Ann Donnelly's ruling. Okay, on the fines. So the $100,000, the $90, and the $40,000. She's going after that. The Judge Ann Donnelly's ruling on that as well. So I'm saying I'm breaking it down like by the rulings. Then if it's something with regards to the law or something with regards to the facts, I'll tell you. And we get down to that. Okay. Got that one. Okay, let me see what this one is. Okay, she is. This is about the. She's going after the that amended judgment as well. So, what was amended in that judgment? Hold on. He was found guilty of counts 1, 2, 3, 4, 5, 6, 7, 8, 9. Racketeering. Man, Okay, so just the third superseding indictment. Okay, or is the fourth? Four. The third superseding indictment, which would be the fourth indictment, was the third superseding. Okay, she's going after that again. Um. Okay, let's talk about these herpes. This herpes shit. Okay. Expert, except provided in. So she's going after. She is appealing the publication for the California Safety Code from May 26th. That I guess it was effective May 26th and effective then the one that was amended effective January the 1st, 2018, and then also the New York Consolidated um, Public Health Code as well. Okay, that's that. Okay, what is this? Okay, all right. So I got so many boxes open. Hold on, let me shut all these except y'all, so I can come run that with y'all. I know y'all probably confused as hell. What you talking about? Leave that open. Hold on. Let me hit refresh and make sure ain't nothing else came out. Go to where? Okay. Wait a minute. 11:53. Hold on for a minute, y'all. Okay. Yeah, thank you. Okay. Now, it ain't gonna make no sense for y'all to read this. Say that now. Oh boy. Cause you're gonna have to put it together just kind of just like that. So I pretty much just told you what she's appealing, right? Things that she's appealing. If they set it up for oral argument, then those are the things that she'll be arguing. So as we see in there, I didn't see any constitutional violations. I didn't see that. Unless she some kind of way skillfully craft that somewhere in her argument. Um, but I don't know anything about the. Oh, wait a minute. Take that back. Take that back. Forgot. So there's something in here. Hold on. What is? I'm so stupid. It's telling me I'm not logged in as me. No, I'm logged in as me. Two ways. Duh. Hold on. And I really want to make sure that to see if she's gonna talk about those highly contested issues that we be going back and forth and back and forth, back and forth, back and forth with on these streets. One, those BOP emails, and two, the text messages and whatever else, right? Now, I'm not saying just because I don't see it in here that when she does her presentation or whatever else, that she doesn't, you know, tie that into a constitutional violation. I'm just saying what I see. Can't speak about what I don't see. The whole entire thing is over 1,000 or something pages because it has the transcript, the parts of the transcripts and shit has all of that included. So it don't make no sense even doing all that. I'm just gonna tell you what it is. Okay. Okay. That appendix. Okay. All right. The juror number 3. Trial of Geronda. Trial declaration. How long? Okay, right here. All right. So she, so everything in her acquittal and new trial, everything. So she's going after, was anything, what was the constitutional violation? What was the constitutional violation? That. Y'all, I'm going as fast as I can. Okay. Okay. So I don't see, and what I'm looking for now, I'm looking for if she is arguing constitutional violations. BOP emails, it's not here. So no BOP emails. Remember, and you couldn't argue that anyway because it wasn't brought up in the goddamn trial as number one. Okay, number two, it was already out there existing, so they wouldn't allow that on appeal anyway, unless. So now hear me. Unless it was, how can I say this? They will allow it. The exception would be if they will allow it as evidence if it would be significant enough to change the verdict, meaning like DNA. Okay, so and when I use the word significant, I'm talking about really a bar higher than that, like it was DNA. All right, and I'm speaking of with regards to BOP emails or anything that was not on the record with regards to this appeal. Okay, or if the judge made an error by not allowing it in, and it was actually exculpatory evidence, right? Then that would mean that they violated the rules of evidence. So I told you, evidence that is supposed to be admitted has to be admitted, and evidence that's supposed to be excluded or precluded has to be precluded or excluded. That's by the rules of evidence. So when that happens, that would be a clear violation. I don't know if she would have an argument with that because we do see that she's going for the emails. I mean, not the emails, the text messages. But is she going to say, hey, the entire document should have been, admissible? Is the entire document relevant, relatable, or reliable with regards to all of it? And so on. I'm kind of glad that this is that this appeal don't, you got to be able to have the skills to decipher through it and whatever, and presented, and it's not the entire thing, because honey, that means I can get to the live I really wanted to do. But so y'all let me know if y'all understand exactly what she's going after. Just let me know if y'all understand that. Do y'all get that? Exactly what she's going for. So in some cases she's going, did she, oh wait a minute, did she go for the evidence? Oh yeah. She's going for the sufficiency of the evidence as well. So that means that she's saying that the evidence was not sufficient enough for a jury to give a um a reasonable verdict, right? So she's going after that. She's going after that too. She's going after that, her decision with regards to Nicole. She's going after the judge's decision with regards to whatever she raised about those jurors, like the surviving Art Kelly, the viewing of that, and whatever those questions are. She's going after that. She's going after, I told you those uncharged acts, going after that too. She's going after that part of those text messages where um she put in her motion for acquittal about, that little excerpt between Azrael and her mother. She's going after that. Let me see. So do y'all understand all that she's going after? Y'all understand what I'm saying? Because it ain't gonna be, nobody's not gonna be able to read it exactly. What you're gonna have to pull it out. So I'm telling y'all now, everybody else that want to read this, y'all gonna have to pull it out. If y'all want to tell your people on your channel, whatever, or you can sit up there and read all those pages. You're just reading old motions, like I said, I want to see if it's gonna be the motions and whatever, and yep, that's what it is. So you're gonna be reading old motions and old transcripts. But even within there, you're gonna have to be able to determine what part is she going after. So anybody understand? Y'all, you get it, Sir Miguel? So let me know if y'all get it. I need to see at least 3 yeses that you get it, because I want to make sure y'all understand. And it's choppy because I had to go through ooh, different, go to different places to get the information. Now, I'm glad that it's like that. So, hell, I'm going to be all to 2,000 years trying to read that entire thing, which ain't nothing but, I promise you, ain't nothing but the old motions. Y'all can go back in the system, read the old motions and shit yourself. Okay. So I want to get to what I really want to talk about. Hey, Linda. So, let me know if y'all get up. It's not there. Right on my community wall. Yes, ma'am, I can. She's challenging Judge Donnelly on her rulings. So here's the problem I see with that. Okay, Judge Donnelly, I told you, when you sometimes you run the risk when you challenge everything in the case, or challenge, when you motion for, an acquittal or a new trial, you run the risk of a judge coming back and outlining in detail her ruling with the and attaching mandatory law and primary law to it, and secondary law, that's case law. So you see where that falls in the line of priorities. What goes first, right? What trumps what? So, and as I remember reading it the morning of the verdict, the judge did a pretty good job explaining her rulings, right? So now, so she'll be. It's not like she's not going to be up against the judge. No, the the bench of judges will, um, look at Judge Donnelly's, rulings and things of that nature. They are very reluctant sometimes to challenge a judge, even though it's a lower court, on their rulings, right? So, ooh. So when it comes to facts with regards to the law, that is the strongest type of appeal. But it depends on, I mean, like, is it the errors have to be like glaringly, like, there is an error. She shouldn't have done that. The judge shouldn't have done that. The judge should have done this. Okay, she didn't apply the law right. She didn't apply the state law, consider the state law correctly as well. But that has to be proven that she didn't do it. I'm trying to think as I talk to when she didn't apply the law correctly. And again, she issued a document on her rulings that explained and expressed her ruling to the T, why she did it and why and again, she backed it up with mandatory law, which is the laws you must follow, primary law, which is the rules and the regulations the laws that must be followed during the trial that's applicable. And then I believe sometimes she did use secondary law, which, you know, prior decisions, opinions that was issued in similar with cases with similar circumstances from circuit courts, right? Which is higher, So I remember her putting that together real well. I don't know if there's a problem, if she's going after issues with regards to the facts in the case, right? That is the hardest type of issue to um to prove on appeal, right? So what are some of the facts? Did the prosecution have all the evidence that supported the elements that would give them a guilty verdict? Was it all there? And I said the elements now, not about the mama put her there in the place and all this, and not all that. I'm talking about the elements. I just need y'all to get to the facts. I'm talking about the elements. I dropped the link. Yeah, so, and then you got judicial discretion, right? The bias, the misconduct of the judge. Was there any behavior such as that? I don't see where J-Bo alleged anything like that. But she is challenging her on the judge on her rulings, which I told you she would do that. Did J-Bo say that? Um, okay, she is also challenging the judge with regards to the application of some of the laws because they're talking about that California, them herpes and shit, those California penal codes in New York and all of that. Was that applied correctly? I'm asking y'all. Like, now, what you can wait to see now is either one, are they going to deny it? Are they going to grant it and order a new trial? Or they're going to grant it and say, hey, send it back to the lower court for them to correct errors and things of that nature? Are they going to set it for oral argument? And again, when I tell you now, the defense has to prove their case. All right.
Hey, Sister Love.
What's going on?
Okay, you said okay. Can you go back to the part where she when she this made when she was said that she was allowing the tape to come in.
Okay. I got to dig that up. Okay. Hold on.
Okay, because 3 days before that, exact to be 3 days before, she had just stated that she was preparing to impeach the main three uh, uh, witnesses' testimony because she said they were inconsistent and they were lying.
She said it was inconsistent and they were lying.
Yes, they were not. They were everything that they were that Canick was questioning them on. They were acting as though they couldn't remember, or they didn't know, or that's what the government said.
Okay. Well, it's not in the transcript because hold on. Let me.
It's not in the transcript when Kennick showed old girl about the case that she had here in Texas, and he literally showed that to her, but it's not in the transcript
Okay. Wait a minute. Let me see.
because it showed that she had herpes before she ever met him.
But I remember in the transcript it said when they asked her, she went through when she talked to her sister about it, and when she talked to R. Kelly about it, or whatever. And it didn't. When I read it before, it didn't say that in that transcript about she had herpes
That's what
when she
I'm telling you,
met.
but I know for sure, and I'm telling you this, and I'm not the only one that saw this. It was other people that stated, but nobody has really brought up the fact that it was not put in the transcript and it was not entered into the transcript. When he showed it to her, he said, "Read to me what you're seeing right now." And it was a police report.
In during Von Jean's motion for a new trial or motion for an acquittal, then she should have. Well, first of all, they're gonna even. I mean, regardless of what people how they feel about Kanik or whatever, he's not gonna. He shouldn't let a transcript go incomplete or incorrect, that if the stuff ain't on the record, especially that you need this to appeal it.
But didn't
That was
she
good.
say that when she came on that ineffective counsel, that he had ineffective counsel?
It was ineffective assistance of counsel with regards to something something else. I think it was
I know
I
one was
forgot.
Nicole, and I
It
think the
wasn't.
other one was Kenneth. The first one was Kenneth, I know, because that's who she let go first.
I don't believe it was. Hold on, I can pull it up. Yeah, I'm trying to go back to that transcript. Hold on. I mean, what was y'all remember what was the ineffective assistance of counsel? What it was, so I can remember what lawyer it was. What was the actual act she was talking about? What I mean, was it? No, I think it was due to the jury. I think it was due
The
to the
jury
jury.
selection? You talking about the jury selection?
Yeah, I think she called ineffective assistance of counsel on that. I believe. Don't give me a line. Hold on.
And also, in regards to Donnelly, okay, let me ask you this here. So, does the judge supposed to be calling these sidebars, or the government call the sidebars?
The both of them can. The attorney can ask for a sidebar, and the judge can call one.
Okay, but why is the judge calling the sidebar every time the defense is getting into that tail, and they don't want to answer these questions, and then the judge calls a sidebar, and every time she calls a sidebar, he comes back. He don't come, change up the question. He just goes to something else.
Yeah, because she probably called the sidebar because his line of questioning was improper or something. That's why.
No, it wasn't no improper. They just didn't want to answer. And one
Well,
time,
probably,
the one of the ladies don't understand. She was acting like she was about to pass out. So in the middle of him questioning her, they get up and start passing a bottle of water, and she goes out and don't come back.
well, if it's the questioning is not in line with the criminal procedure, I mean he can't be allowed to continue those questions. So you have to stop him or call him up there to see where he's going with it, or or to advise him he
I
need
mean,
to.
that many sidebars, Angie. Come on.
I
Every
mean,
time this man get up to
it's
ask a
not a limit.
question.
It's not a limit. I mean,
But
they
I'm
don't
saying
call
every
sidebars.
time he gets to, every time, everybody that gets up there, that he starts to digging into their butt and really getting deep into questioning them, she's calling a sidebar.
It's probably something that was improper with the line of questioning. I mean, it's no, you don't have to have like two sidebars, no limit or whatever. If they have to call 100 sidebars, that's what they would do. So, wait a minute.
I mean, the government didn't never say, they didn't say anything because they didn't have to say anything because she was going to call the sidebars on their behalf.
Uh, I mean, I mean, I can't. I mean, I wasn't there in the courtroom. I can only go by what's on the record, whatever, then I can only go by what his attorney in the
Even
post
what's the
said.
name? I don't know if you was over to Sylvia's live when the attorney from Dallas, because she was there the majority of the time in New York, and she said, "I've never seen anything like this before in my life. I've never seen a court," and even the media was saying the same thing. They never saw anything handled the way that she handled that courtroom like that in their life, because it was very it was run by her pretty much, and the government didn't really have to do any work because she was working on their behalf.
Well, if that was the case, then J-Bo should have had this as a part of her appeal. Nothing in here with regards to the judge's conduct or misconduct or her discretion or her bias or anything like that. That is
So would
definitely.
that have come from his team, his side? Would they have had to put that uh, in the transcript or no?
No. She can based on whatever, she could say that that's a constitutional violation. That's something totally different. It's
Okay,
constitutional
so let me
violation.
ask you this here. So if they didn't put it, if his attorneys did not put whatever, pretty much what I'm saying to you that happened inside his courtroom, will Jennifer have access to see, will it be on video? Is it a video or something that she can go back and look at?
Yeah, it's recorded.
Okay,
It's recorded.
okay,
It's recorded. But yeah, I mean, I'm not saying if anything like that would ever happen, then Jennifer may have it in her oral argument if it's set for oral argument. But she should have included in her brief. She should include it in her brief because they are going to either you know deny it or grant it. They really don't have to set an oral argument. They'll either deny it or grant it or send it back based on her brief.
okay.
Yeah. So.
Because she even stated at his sentencing in Chicago, when she got ready to get up, she said, I, I haven't, we haven't uh, said anything. We just sit here and we listen to you. You know, we agreed to a lot of the terms that you guys have put out here. We did not debunk a lot of things, but at some point, I have to say something. And right now, you guys are saying that this man is living his best life. This is what the government was saying, that he's living his best life. And you're presenting it as if, and this is when the judge stepped in, they were presenting as if he was found guilty of obstruction of justice. And so that's when the judge said, um, are you forgetting that I was in the same trial you guys were in?
Oh.
Because a lot of
Yeah, she
things that
didn't. I
they were
mean,
saying that happened did not happen in the trial. And because based upon what the ladies got up and said, none of that was stated in the trial, even when they got up to give their, what they call it, um, that was at the sentencing, when they read the, what is that they call it? The
the
victims when they
verdict.
read,
The
huh?
verdict.
No, the victims when they're reading their
Oh, impact statement.
yes, impact statement. Everything that they put in their impact statement, none of that transpired during the trial. And that was a lot of what the judge was saying. I'm hearing all of this, but none of this evidence was presented during the trial or mentioned even in the trial.
Oh, I don't know. I don't have a clue. I can just go by what she submitted and try his best to see, what she is objecting to, what have you. If there, there could be um some more, the defense is the one who set the time frame for when they're filing their brief or whatever. So
Right.
I mean,
Because
but
even the judge stated in Chicago, there shouldn't have ever, he stated that, I recall him stating, he said it more than one time, there should never have been a trial in New York. I'm still trying to figure out, why was there a trial in New York? Why did we need two trials in two
what
different uh, jurisdictions in New York and Chicago, when it's pretty much the same case?
I get that. I mean, as far as you're saying is overkill, but if they have the options to do that and the venue and the jurisdiction um is appropriate, then I mean they can do that. So it's just, I mean, I don't know. I mean, stuff if you said the stuff was supposed to be in a transcript, then between all those lawyers he had on that side, then the transcript should have been corrected to reflect that, or a motion should have, if it
Exactly.
a motion should have been put in, but uh, Jennifer Bonjean would do it too. So if she ain't do it, then I don't know. Most likely it wasn't on the record and didn't occur. So, but anyway, so listen, y'all. So we need to talk about this other stuff because y'all. I told y'all that I was going to go. Oh, Nisa, you had some more questions?
No, 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 no.
Oh,
I thought you was looking up something. No,
oh no, 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 no. I was going to talk about this text messages and stuff. So you got a something else on in the background? 'Cause I'm looking.
Let me. I'm gonna go back in the chat.
Okay.
Okay. Bye bye.
I know I ain't fall. Show how I'm fall asleep on y'all, and I'm still up here talking. So let's see. So y'all, that's about all it is on those appeal stuff. Let me let y'all clear y'all head from all of that appeal stuff, and I'll kind of touch on it again. But I think I've said it so many times. But apparently, I don't care how many times I say it, it's still, I guess, get lost somewhere in translation or whatever. So I'm gonna try to give you a more it's been a minute, not a minute that long, but since I really went over appeals and the reasons why, right? So I told you they can appeal the facts in the case. And this is what the facts are, what was used to prove the government's case. Okay, the evidence that proved the elements, what they used. Okay, so remember that is what they used to prove the elements, not the backstory, not somebody flip, not all of that. We're talking about the elements. Okay, the evidence they used to prove those elements and the facts in the case, what we know to be facts. If you say I have herpes, is there some, well, I'm sorry, if you say I expose you to herpes, is there something proving that I expose you to herpes? So if I have herpes and I slept with you and didn't tell you, that type of stuff, okay? Not nothing that was isn't there, not no hypotheticals or whatever, okay? Now it can be evidence that you can draw a conclusion from, meaning just say most cases are, most cases are circumstantial. Just say a building blows up, I see somebody running away from the building, we could say, we can draw a conclusion that the person that we seen running away from, well, let me put a little bit more to it, running away from the building with a bag that say these are explosives, that's something we can draw a conclusion from. That's also allowed. So I just want to make sure you understand that. So those would be all the facts and the elements and all that goes together to paint this story. Did you, so you can ask some questions based on those facts and the elements? Would the jury be able to make a reasonable conclusion based on what they heard in court, based upon the instructions from the judge, which is the jury charge, also known as the jury instructions? Would they be able to make a decision based on what they had? J-Bo challenged that when she said the evidence was insufficient. When I say insufficient, we're not talking about the amount. We're not talking about the quantity. We're talking about the quality. We're talking about the 3 R's: the relevant, relatable, and reliable. We're talking about that. Okay? And here's another is a fact that when it with regards to appealing for that matter, for the facts and law. Okay, the appellate courts, where the case is now, have been warned by the upper courts, to stay away from intervening in the decisions made with regards to the facts in the case, right? Because what they're saying is they are, based on their statistical data, that the judges have done an overwhelming correct rulings, allowing the evidence and making sure that the facts supports, even having the facts and the elements supports even bringing a cause of action, which is an indictment, and so on and so forth, and the prosecution proving their case. That's why most of the states, remember, states like way back in the day, most of it was charged by the prosecution. Now they're moving it. Most states have just used the grand jury. Some states have an option to either use a grand jury or let it be charged by prosecution. With feds, it's all by a grand jury. Okay, so they're saying that process kind of sure up uh, that the case will be brought based on the proper merits. Okay, so you have that. Okay, and she did a lot of challenges with regards to the facts, and it is a hard sell, but hey, it is what it is. Then you got the issues with regards to the law. Did the judge make a proper determination about the law. Is is this in fact a RICO? Is this in fact, I mean, does it meet the qualification? Let me say it different because y'all say no. Doesn't meet the qualifications to be a RICO. Is it 2 and 10 years and all the other along the line? Um, is the correct binding authority being used for that particular state, right? Is the age of, and this doesn't really apply, but is the age of consent in that state 17? Or what is it with regards to um, exposing people to incurable diseases? Was the law applicable? Was it used correctly? Was it relevant to the case? Was the actual law relevant to the case? Let's see, Mann Act. Mann Act would be a good one. When Mann Act was developed, it was for immoral sexual acts, cross state lines or whatever it is. I don't know it word for word, but whatever it is, was that applicable? So, applying the correct law is the strongest type of appeal because that borders on being a constitutional violation. If you got convicted under the wrong law, that's some bullshit, right? So that is a glaring error, okay? And then, of course, judicial misconduct, discretion, bias, whatever. Y'all know what that means, okay? So I just wanna, so it ain't no hypotheticals and all of that. It's not what's not there. It is all what is there and what can be proved, okay? So that's what you got to look at. And in this case, they have to answer this appeal. So it's not one of the types where the appeal, you may never hear anything about it, or they refuse to deny it or whatever. They got to review it. Okay, they have to. So you're gonna get an answer one way or the other. Okay, so I make sure we understand that. Ooh, excuse me. Now, this is back to the fun stuff. Okay. So anybody, y'all get it about these appeals and shit. And I'm gonna tell you right again, right now, if you just wanna take your time and pay a whole bunch of money to Pacer to download that whole entire thing, go right ahead, be my guest. But it's nothing but the old motions and the transcripts, okay? Which we've already gone over. So some of the stuff I want to talk about. I want to talk about like the Q's and A's I be having on that the discussions I be having on the message boards and things of that nature, and just some of the answers and whatever that I've gotten. I have no idea why, but it's some of the stuff. It was just plain as black and white what I was talking about. But when people have a problem with you, shit, that's where they go to catching. They can't catch you nowhere else. That's where they go to catching to try to make something out of nothing. Which I'm not going. I'm not going to be back and forth. I don't. For what reason? It. Some people are miserable and messy and things of that nature. And you got nothing to do but fuck with people and have all kind of mental motherfucking breakdown on, and then you bring your ass on YouTube and fuck with people. So maybe I got time for that. So I have put something. Maybe I'll go different. I'll go out of order. I'll go with the Don Russell thing tonight. I saw the Don Russell interview, and I thought that I mean, I could tell when he was not. I don't have to know nothing about the actual be there when this happened, that happened, whatever. But it's just certain, certain telltale signs you could tell when people are lying, when they are lying about certain things, with regardless whether you there have been there or not. You know it's a lie because like some shit just don't flow that way. Okay. And they've told different stories, or they told stories that is just so unbelievable and ridiculous. Now, while I can never take away from what he allegedly did as being a friend for someone, because that is putting it on the line big time, you know and I'm not gonna say that you should break the law just to help somebody, whatever. But I say oftentimes that sometimes good people do bad things for good reasons. All right. And they are both principles on the streets and they are principles in the law. Unfortunately, I'm down with both of them. Unfortunately, I'm down with them. That's just what it is. Because I cannot erase a history with people or being around certain environment, things of that nature, and knowing this type of people. Hell, I got a close friend, on not a close friend, but was kind of close back in the day, that's on death row, and people that's doing life, you know and then everybody I know ain't exactly on the right road, or they weren't always on the right road. So it's a whole mixed bag. And I got people that shit, you know, live by the letter of the law. So hey, that's so I say it's principles both on the streets and in law. So I won't, you know, knock him upside the head for that in which he was allegedly accused of doing. Now, but this epiphany he's having and running and telling and talking and whatever the hell is going on, that's a little bit concerning, because a lot of some laws, I'll say that some laws, the changes start when you have a group of people descend upon changing the law, right? They start talking about, particular cases and where injustice was, experienced, or things of that nature. Such as, so, you got this movement going with regards to, maybe just say the text message and the BOP thing and blah 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 whatever, and it can be an argument some kind of way for a violation of, due process rights, constitution violation, what have you. Okay. And then you have somebody coming out now that we know, because we seen that he had actually, we don't know nothing, we don't know how close they was, we don't know how his friends, whatever, but we know at least he knew him because he came in the jail. He came to help turn him in or whatever the hell. So we know that you was associated with them. I think his one of his pictures was used as a part of the RICO, part of the enterprise. So what you have to say may carry weight, may carry a different weight, as in some daughter who nobody believed now in their right mind. Nobody believed but Jaguar Wright, I guess. That asked R. Kelly daughter from Aaliyah. Ain't nobody believe that. Hell, ain't nobody believe that shit. So that's more of a can you believe this bullshit type of, movement that's going around with her. That's different. But while what he's saying, Don's saying, won't affect this brief on appeal. However, just say he's granted a new trial. And grant somebody a new trial does not automatically mean you're going to get more years. That is not how it works. You can get more years if the prosecutor, if they find some kind of other codes to charge them under and so on and so forth, whatever, or they some kind of way they agree that jeopardy still is attached, and then this he is able to be retried, then he could possibly face more time. There could be more charges added would that carry a different length in jail or whatever, right? So that's just what it is. So just say that happen. Now you got Don Russell making what is known as statements. We talked about statements. We talked about Santiago Profo. We talked about hearsay with your statements. We talked about statements. But statements can be used against you. If it's allowed, it comes through as a hearsay exception or exclusion, right? It gets in that way. If the statement isn't used to assert the truth of the matter that's in the statement, then it's not hearsay, and then it's also admissible. And if he's saying that R. Kelly told him something, that's not hearsay. If it's related to a crime that he's being charged with. So that's how this plays in. Okay? Then you have that. So, I don't know what the fuck is going on, I don't know if he's been made some type of promise. Well, who knows? Who knows? I mean, from what I can understand, he knows his way around the law. He knows some slick shit, so whatever. Who knows? And somebody could, I don't want to go into all of that, but I'm just saying, it won't play as a part of this brief on appeal. But suppose they say, get a new trial. This man is out here on the record giving first-hand accounts of shit. That's direct evidence. So, anyway. Anyway, I don't know. I just have to blow. I don't know what to say about all that. So, the last live I did, right? We were talking about the parents, right? And I was saying that I cannot say that one parent's set of parents' actions is different from the others, as far as like, should we hold one in high regard and the other not, and whatever. Or I can even separate the 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 couples and put in the individual parents and whatever. And I can't say, I can probably say, in my opinion, I guess Mrs. Savage would probably be more the parent that I would think that's acting correctly with regards to this situation, because I was just talking about, I mean, I heard Tim Savage talking about, we got a wife for life, you're gonna make the millions or whatever shit. Then last night I saw this peculiar little spot he put out. I don't know if he was reflecting on as P. Diddy or whatever. The weirdest shit. It's just the weird shit like that. And it looks like they always need for some type of, if it was exposure just to have some type of awareness about his situation with his daughter, as far as he want to see it, blah blah blah, whatever. Then that's what I would expect somebody to start off with, saying, "Hey, I need my daughter to come," blah 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 blah, trying to appeal to the society. And that's what I'll be ending. Not about no interview. You want to interview me? Come over here. Not about Savages on no vacations. Not none of that. Because I don't understand none of that. So that's why, I just think everybody's full of shit. That's what I'm coming to that conclusion. And all I know, if any one of y'all come near me, I'm shooting you. If I thank you from the motherfucking YouTube, I'm shooting you, because I'm convinced something wrong with you motherfuckers. And I'll be doing you a favor, because first I'm gonna try to shoot you in your leg so that you can, survive, and you'll know better not to walk over here no goddamn more. But if you keep coming after I shoot you in your leg, I'm gonna have to go where we train at, the biggest part on the body, because something's wrong with all this sound. This is weird shit. I'm not gonna ever understand how everybody was a victim. I'm talking about the parents now. Everybody was a victim and lock and step and everything, and falling out, crying and moaning and groaning and whatever. And then everybody get mad, and the sincerity that was supposed to be there from the beginning, and the shit that the good stuff that the parents supposed to be done from the beginning. Now all of a sudden, none of that happened. Everybody bad. Everybody like Immediately when I see and hear that, I'm automatically, here comes the bullshit. Because I've experienced all that kind of shit. I was a lawyer before, but when you get mad, no, she ain't. I was like, well, goddamn. All that kind of crazy shit. Weird shit. And so I listen. Mm-mm. I don't do that. That's not what, that's not my thing. If I have something that may change my mind, but I'm not going to say I witnessed something and didn't witness it. I'm not gonna do that. If I witness these parents going to the edge of the earth and shit to get the kids, then I ain't gonna turn around and say no, they weren't doing shit. That makes my credibility under a fair attack. Cause you should. Like, what the fuck? Cause I could have wrote you big checks based on what you say is what the deal is, and then you said that ain't what. I'm like, what? So I don't know. But it ain't for me to talk about. But I'm just saying that is just my thoughts on it. I just thought that was so weird. That little bad boy come out to play shit was just. I said, you know what? I can't. That's why I personally like the Rogers. I don't get all this. I don't get all this. I don't know what is going on type bullshit. I don't get all those um that kind of thing that makes me looking like not giving a side eye. My whole head be to the side. Like what? So yeah, I can't do all that. That's too much for me. It's a hot ass mess. Shit. Yeah, that was crazy as hell. Like I was like, yeah, I'm like the bad boys come out and play, and and I'm not no bad whoop this that and the third, but he was putting down the bad boy, like yeah, and he ain't say this, but yeah, I rip you up, I turn into a bear when you come over here, that kind of vibe. I'm like, now you know what? Now y'all know I fight men. I think I hit you for real. I think I won't be scared. I won't be afraid to hit you. It's some men. Y'all women. If y'all women, some of y'all, don't mind putting a two or three fingers on one of your men. Now, you done got down that way and shit. You done it now. But them crazy ones, not to hit them. Hey, them motherfuckers, for a fact not to hit their ass. You be like, hell no, hell no, I'm gonna talk this shit over the phone, baby. And I'm gonna be looking out the window every 10 minutes for your car and shit. Hell no. call my people and we gonna, there's something wrong with you. I know not to hit your motherfucker. Baby, I'll never forget. I fucked around and hit the big bad wolf. I don't know why my hand, and it was my right hand, but and somebody else had to be holding it, because this boy was really bad. Meaning everybody know, baby. He was listen, do y'all remember when I had that call with him about Ramon and he was talking about I roll around with security and the people and my exes did treated him bad and they always just do stuff to him, whatever. Well, this one I'm talking about was one of those, was the main one that was giving that man po hell. That man refused, that man was refusing to come visit me anymore, all that kind of shit to this day until he is sure that I got my family to secure him. It's child. That's why Ramon sound like he is scarred, right? So that boy, let me tell you something. We was arguing and my right hand, because I wasn't in control of it. Because I knew better. Yes. Yes, you heard me say that. Angie knew better not to start no shit and not to even respond to no shit with regard to this motherfucker. I don't know what was in me, but I wasn't in control of my hand. He was saying something, and my hand just came across his face. What? And listen, I hadn't known that I had done fucked up because I was steady saying I was trying to get my hand to come back, but it wouldn't. And baby, when I tell you, I stood there and I froze. And he looked at me and I looked back at him. He looked at me, honey, I think I stopped breathing. He walked out that goddamn door. He looked at me so hard, I'm trying to tell you, baby, he do the intimidation look thing. He would come over This is after we had them broke up. Wow, baby, probably about some years. And my friend Nita, I was dating somebody else, but he was over there. And my friend Nita came in that house and said, Angie, so and so say he finna come over in a few minutes. They getting ready to leave. And he looked at Nita, and Nita looked at him, and he was looking at me, and baby, we was in a three-way stare. I ain't making none of this up. I think I got some calls from his partners and shit. Talk about the yes, baby. I would listen. So I ain't no goddamn fool. Uh-uh. I know who. Hey, I know who to where to go and who to fuck with. so, so Mr. Savage didn't give me that vibe. I would totally be like, he talking about you fuck with the Savages. I'd be like, yeah, I would fuck with the Savages. I'm not gonna be scared. You in the Batman video and none of that. I'm not gonna be scared. You, no. I don't know. Maybe you should. Maybe you should have. No, I'm not gonna be scared to say shit about you. I'm to you. I'm not gonna be scared. You're not gonna make me nervous. I'm sorry, but yeah. So that was crazy as hell. Um, Hold on. Oh, so I went over there. I wrote this lab down what I was getting ready to go over. So about the wall, right? I was speaking about client driven motions, right? Client inspired motions, which are what I started out speaking about. And your client is in control of his defense team, right? You most times serve as a consultant, advisory. Most of them let you do your job, this, that, and the third, whatever. But if they ask for something that is humanly possible that you can provide, that's what you're supposed to do. That's what they pay you to do. Now you can advise that it's a good idea or a bad idea or whatever, but you're supposed to do it. And I feel that the that BOP motion was a R. Kelly inspired motion. Not saying that he shouldn't have. That is not what I'm saying. Okay? That is not what I'm saying. I ain't said he did anything wrong. That's not what I am saying. Sometimes you have clients that just want to get out of trouble by all means necessary. And they are willing to try any and everything. And you're supposed to make that happen within the confines of the law. That's what you get paid for. Or they'll just simply fire your ass and get somebody else to do it. So, the reason why I say it was because when you look at that BOP email thing and you see the response from the prosecution was already in. They already detailed that they had an investigation. They already detailed what came out of the investigation. They already spoke to the fact that it wouldn't be um, perceived as prosecutorial misconduct because there was no Brady violation. When you know that that situation happened, it was out. It could have been addressed during the New York trial in great detail. Apparently, it was not. Came up during the Illinois trial. So I believe, and because the the actual narrative ran out here about the BOP email. And so I'm probably sure R. Kelly was told about the BOP emails. He thought it was a good idea. It probably seemed as one, you know, and because that that lawyer knows goddamn well, no reading no emails and flipping her is some kind of legal, a sound legal argument. Now, I let people run with their theories and cultivate their theories and whatever, and they will either sharpen it, make it applicable legally, or they will, and I'm talking about students now, I'm not talking about y'all out here, or they will throw it out and come up with something else. But they make their own determination of what they want to do with it. So I don't shoot it down. I don't shoot it down for them, right? That's what they come up with. Especially when I used to teach strategies. That's what they come up with. I let them work it. They fine tune it. Whatever. But that lady knows that don't make no sense. That's not, it don't make no sense legally. All right. And that's what I would consider a illegal defense. Because if you can show somebody something, they are more than welcome to change their mind to help you out on your side. That's not a problem. You can pay their rent. If you can pay their rent, witnesses rent, if you can do this, you can do that, you damn well believe you can show them something and they can change their fucking mind and get mad at your suspect and help you. That's called cooperation. Now, if the if what 18 USC, what 1512, that mainly pertains to defendants. When that happens, for as to cause somebody to corruptly persuade somebody not to testify and this, that, and third, and whatever. That's mainly applicable to defendants. But now I'm not saying that the prosecution gets to bend the law with regards to, witnesses or victim witness and things of that nature. That is not what I'm talking about. But I'm saying that is not considered breaking the law when it comes to a victim. I'm saying J-Bo knows that. And I'm also saying that when you read her motion to compel, she references the defendant several times in saying the defendant has reason to believe that the information that was leaked in those emails and stuff was attorney-client privileged information. Pretty sure they came up with that together. But nonetheless, she surely says her client believes. It's also an indication to me that that is a R. Kelly driven motion. It's just my opinion. That is just my opinion. And when J-Bo did also say that she don't speak to one of the bloggers that was running with that narrative, that's another indication that it had to come through her client. Because I know damn well she wouldn't have said no shit like that. Just being honest. And meant it. And meant for it and think it was going to be. And then the fact that, it wasn't really, I don't see nowhere where she pursued it or whatever. And we do know that she liked to kill two birds with one stone when she writes her brief. You seen, and I've pointed out several times, that's when you're getting to getting into the profile of like an attorney or whatever, knowing their ways and whatever. When you look at how she submits her briefs, you see, like, if she, even if it was denied one time, when she writes another brief, she will bring up that what happened, with such and such or whatever, because she's a firm believer in when she submitted that motherfucking, you know, submitted that goddamn motion before, whatever. I don't believe that she kept doing that with the BOP thing. I may be wrong. I still haven't went back and looked up the subsequent motions she filed after she put. Well, you know what? It came out through Illinois. That was a New York situation, but still, she could have maybe mentioned it in the Illinois. It wouldn't have been applicable anyway. But anyway, so, and also especially because she did it during the Illinois trial, and damn well it's not on the record in New York unless it's in the transcript somewhere. And if it was in the transcript somewhere, then she should have brought it back up during appeal, or maybe, or during the post conviction motions phase. So that's what I mean. And just because it's a client driven motion doesn't mean that it's wrong or whatever, wrong to file. It just, you can just tell, if you've been looking at them long enough or whatever, you can just tell when it's one. You can just tell, because you can kind of tell that you got to, because with those type of motions, you got to really reach. You got to make it do what it do. So that's what I mean by that. Um, when I say illegal defenses, right? I mean defenses that are already barred because it is prohibited just by law. The law automatically affects the cause and effects of the action, so it's already prohibited by law. Meaning this, okay? When they say that they put as the gender number 5 in that predicament with a grown ass man, and it's their fault that you know she allegedly had sex with him under 18 or whatever. For one, you have consent there. The parents cannot consent for their child to have sex under 18 with an adult. Even if it wasn't consent, if it was implied, if it was, implied means, you ain't say it, but, you gave the illusion it was okay. It was some, whatever, anything, either consent or you implied it some kind of way, or just by the nature you taking allowing your child to go, that was consent or whatever. That is not consent. You cannot consent if you are under the influence and you're an adult and you said you had sex with somebody, so you better be careful out there having sex with these people and y'all drunk, because that's another, that is, that you're unable to give consent that way as well. So what I'm saying is there is a law that prohibits your defense. That's why I call it an illegal defense. This is a law prohibited. Also, if you're a drunk driver and you hit somebody, you can't say, "Oh, I hit them because I was drunk." Well, there's a law that that makes it illegal to drive drunk, right? And you also can't say, "Well, it's the fault of the bartender because he should have cut me off. He knew I was drunk." They should be going to jail for it, not me. That's all illegal because there's a law that prohibits the cause of and effects of your actions. It's a legal defense. Okay, that is a term I came up with a long time ago. So, and that's how I explain it. Okay, so now talk about them goddamn text messages. I think that's where I am now. Okay, so I had to look through those text messages. Do I still have them up? Hold on, because we want to talk about these text messages. Now, you know what I was looking for? I was looking for the extortion. They tried to tell me that was in the text messages. I was looking for a whole lot of shit. Now, let me go on record and tell you this right now. Those text messages are horrible. When I tell you, shit, like there is no way in hell that I would ever talk to my child like that. Now, I can tell you this. I'll go back to what I said one time. I said, not when I said a few times, after I thought about just what J-Bo had shared with us out of those text messages, that I believe, although her mother didn't say go ahead and have sex with them, I kind of believe more now that even if she would have, I believe it would have been okay by the mom. That's just my opinion from what I read. And I had already said that, several lives ago, long time ago, after I went back and forth because I just couldn't believe, as a parent, that kind of fucking shit would be transpired. But that's just I might be wrong. I'm not trying to offend nobody. But listen, I do believe that if something would have went down, and the mama would have known about it, I think it would have been okay because there was a lot of instructions in those text messages that was kind of putting her down on with game. And I'm sorry if you are 17, 16, or whatever it is, and if your mama and it was so crazy. It was the daughter was like doing the resistance, like no, ooh, like for sometimes or whatever. I don't know if that's just a game or whatever. And I'm still hoping that their relationship was just like that. It's a kid and a joke type of thing, but it's like like don't give it up right now and all that type of shit. Like, well, is there a time frame for me to give it up that you would be more happy with? Like, what kind of shit is that? Like, I don't, uh-uh. So I do believe that. But nevertheless, I did not find anything about no food truck, no offers of demands of no money, no demands of no, well, he gonna have to do this and that type of way. Although I didn't read every word of them. I just looked for the words that would be in line of a scheme, in line of extortion, a line of a setup or a frame, in line of things of that nature. So I look for those words, and I wrote them down. So the booty pick, it was just a booty pick. Not saying that it's okay to tell your daughter send anybody a booty pick. Shit, that could be the precursor to a goddamn look at me talking about it. Being a goddamn one of them motherfucking people on the what the cam girls or what did the shit call it, the with the sex, the bappers, the pornos on the video. But um hold on, I know what I can do. Okay, so that ain't gonna work. Okay, right there it says, and I'll read the line. It says, he sing keep it on the down low and sung it all to me. Incoming LOL, wow. Didn't he didn't even sing that the last time. You gonna have to send him a booty pic, a big booty shot pic. LOL. She says, laughing my ass off. Incoming, girl, he gonna really want some of you after tonight. Now, okay. Now that ain't cute joking or whatever. Some people have relationships with their children, even as an adult, like that. I don't. I don't know nobody, at least on my mom side, that, uh. So that's the situation with the booty pic. Okay. Um, Another word. I did. I saw efforts of her mom trying to get a job and her daughter trying to look out for her, trying to get her a job. All right. I saw that. Again, it's not a scheme, it's not a setup, it's not extortion, it's not none of that. That's what I saw. Okay. So I saw that. I saw, and another thing that kills that extortion thing, whatever. I saw that the parent, or at least the mama, was constantly sending her money. She was asking her mama for money, and she was constantly sending, which it would seem like if it was some kind of setup, the plan to start the scheme or whatever to get some money, she should have been asking him or demanding some. So you have to get your shit together when you fucking with me. Yeah, that's what I saw. So a lot of her looking out for her mama, trying to get a job, and her mama sending her a job, sending her money and shit. Um, what else? What is this word I wrote down? Like keyword. Hold on. Um, I thought that and what was further, let me back up somewhere. Further made me think that her mom, her mom could have even known that it was some kind of sexual something going on, and that most of the story about they didn't know who he was, they didn't know this, they didn't know that, whatever, was most likely not the truth, because she was saying that she's loyal, she don't talk, she know how to be down, this, that, and the third. Wow. That is saying that you will be okay with whatever you see that's going on. So that lets me know in your head, something's going on with something. Something not right, allegedly, was going on. And you was okay with it. That's my opinion. Um, I felt that in at times. She could have been seen, and this is on the line. Let me see. Let me go back to 54. Where was this at? Because I want to read exactly what it is. I mean, yeah, it's nice. Make that matters as long as you. Okay, I'm okay. So here it says everyone having fun, and Kel said, "Do not leave the room." Incoming, the mama. That room, that room is nice. I'm glad he makes you happy. That's all that matters. As long as you're not hurting or anything crazy, I'm okay with it. Huh? And it's good for you to have someone to talk to and that will listen to you and give you the truth, even if may not be want but what you want to hear. To be honest, that's all I ever tried to do, but you don't like listening to me, lol. Now, you can take that two ways. You can say you have someone that is functioning as a mentor that you listen to for advice, whatever, or the dark side is that you're saying, like, these people are a couple, and this was 5/3/2015, and you glad he makes her happy. Then it goes on, but it's more the latter, because it says, I'm glad he's not rushing or forcing you for that he gets, I don't know what all that is, because that shows he has a lot of patience. Patience is a virtue which many don't possess. I don't know what's going to happen with y'all, but I hope y'all remain friends so you can have someone to talk to. So you may have to tell him the truth about your age. Because of tonight show. Oh my God, LOL. How come we've been up since? Okay, let me. I don't have to read that. Like now, huh? What you mean? Now that tore my head off. That just tore my damn head off. Like, what do you mean? You glad you got, huh? And y'all, I be looking for. I go for the look for the good and the bad. But goddamn, but you have to call it like, glad you got somebody, huh? Ugh, ugh, shit. Mm. Yeah, I done forgot y'all there. I'm still, hey, I stopped talking and started thinking. Shit, what the hell? I forgot y'all. Hey, I'm old shit. I do old folks actions. I'm like, huh? What the hell you mean by that? Huh? Like, and unfortunately, well, here's the thing. Here's the thing. Could the prosecutors could have made something that might have gotten. Now, this wasn't a free no R. Kelly. This wasn't a free no R. Kelly because there is no law that says there's no law with regards to this. I'll say this with regards to sexual exploitation. Um, that you can't be treated into a crime, right? And while you can give consent for your underage child to marry an adult, you can't give consent for them to have sex with them. If you do, your ass goes to jail. Supposed to. And remember, there's that thing, prosecutorial discretion, meaning they get to pick and choose who gets prosecuted. But go back to what I was saying. There's a reason why I told y'all about, you know, facts. Facts in the case. Facts are the elements and those things that supports and improves those elements, like, the different parts of the story that is factual in the case. Different parts of the story. Okay. There's also a thing is they consider in court the conclusion that is drawn from those facts. While it may not have done anything about his criminal liability, and it may could have mitigated in some kind of way, meaning he would be less guilty but still guilty but less guilty, right? When it comes to the parents, or not the parents, fuck Angelo, he ain't in this. The mama. If you can draw conclusions from it, and you're using the same evidence as present, you're drawing conclusions that at some point, allegedly under 18, because this is the evidence the prosecution is using, that she was under 18 when she had sex with him and and was exposed to herpes, subsequent therefore catching it from him allegedly. Because this is your evidence. This is prosecuted evidence. So it's fair game for them to use that evidence to convict the mother. The prosecution more than likely did everything to keep the parents out of the equation. And they did a damn good job of it. Because sometimes you have to drop your evidence if you don't want certain people to be pulled into the equation. Probably shouldn't have said that, but it is what it is. So you can, and so that's the same evidence. So and then you look at those text messages, and you later find out that they allegedly had sex prior to her being of age to consent and all of that. There could have been a way that the mama could have been charged with some of the same things that he was charged with. It could have gotten that bad for her. Because you kind of reason why she got exposed to the herpes. You kind of reason why she traveled across that state line. You kind of reason why, you know. Same concept is, I know it's here in Florida, you pull out a gun, you with somebody pull out a gun, somebody gets killed, even if it's a person, that's with you or whatever, all y'all get charged with murder, maybe some variation of murder, but you all get charged with it. Yeah. She lucky. So I don't know if the prosecutor maybe understood that, they were put in a in a in a in a spot or whatever, and maybe that's why Judge Donnelly said the parents are, who they are or whatever, meaning that they is who they is or they are who they are, you know. Maybe that's why she made that comment. Because this is shit. Oh, I don't know about the lawsuits, but yeah, they could. That is yeah. I mean, she got lucky on that. Being some shit like that. Because when you're dealing with circumstantial parts of the case or whatever, then it's the conclusion drawn from the evidence. So it's not have to be direct. It's a conclusion drawn from the evidence. A prosecutor could have made a story with that. Mm. My. Now, one of y'all kept saying, you need to read it. Hold on, I don't want to go. Hey, I was keywording the words that, that I knew that could have a legal circumstance behind it and shit. I don't want to read it. Hey, like, huh? I was like, and I don't want to say this. I don't want to offend my white people or the white folks in my family, whatever. But baby, that is white folk shit. Niggas, we just don't do that. No, we don't do that. We don't do none of that. We don't do none of that, baby. None. Shit. Give a damn about no. It can be R. Kelly, Kelly Price, Kelly Clarkson, Kelly, Kelly Rowland, any of them motherfuckers. Any kind of shit like that. We showing the fuck out. This white people shit. Don't mean no harm. Don't come fucking with me. But no shit like that. You know? We're gonna have to do better than this. We're gonna have to do better than this, child. I mean, that is evidentiary facts, the conclusion drawn from the evidence. Like, what the fuck is going on? Shit. That is, and the and so with regards to the revelations of the text messages, will the text messages free him? No. I'm just being honest, without playing. I'm not playing around, but I see that we're either gonna be stuck on keep repeating the same vicious cycle, or we on some bullshit. And I don't do either. Will the text messages for him? No, because if you use them, you use them to support an illegal defense. If you say that they could have been used to create reasonable doubt, yeah, okay. Just say they were in, and you use them for the only thing you can use them for is create reasonable doubt. Yeah, but that prosecution gonna sit up there and say, hey, they're gonna go down, start talking about consent. So you're gonna be right back where you were. You think the prosecution is not gonna get up there and defend against? They use the law to defend against it, against those text messages. Exactly what's gonna happen. They wasn't stupid. That's why they admitted certain. It's just that's just a lot. This is white people shit. No offense. We don't do all this. My daddy would have been sitting there with the gun on his lap when I'm trying to sing. Everybody was in the I ain't say that right. Let me say it right. Everybody was in the I need somebody to know you in, yeah. You was in the choir, the warm up. A E I O U, A E I O U, A E I O U. I said, Miss Angie, how much shit you do? Hey, A-E-I-O-U, 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 A-E-I-O-U. Damn. What is a yeah, the warm up. Shit. What is it? What is it? Drum. Come see the boom of the drum of the horses ching ching chong. Calliope's popping high and shit, I don't know. Running. Moses under how you have much delight with the rhythm of the drum. Come see the other horses ching ching chong. Out of out of time, out of skin piping up his chart, piping highest. And I get Sabrina on the phone, and she'll remember it. But yeah, yeah, that's my little touring days. But honey, white folks shit out. But the thing is, now when we get to the 2255, rid of habeas corpus, then now you're gonna say, well, Miss Angela, because I'm gonna be talking a little different. Because when we get there, things that was on the record and off the record are allowed. It doesn't change the law. It just changed the presentation. All right. Sometimes you have to argue that the law itself is illegal or the law itself um well, I went over what when the law itself isn't applicable in cases, but the law itself isn't constitutional. You have to argue that, but I don't see where it would apply in this case. But I don't have the records. I don't have the case and stuff like that, so I wouldn't know. But I just don't know, and I'm just not big on the. I'm not saying nobody's tell oh, you doomed. It ain't nothing gonna get y'all. Ain't that, no. That's not what I'm saying. That's all I'm saying. Okay, that is not what I'm saying. Because the law can change today or tomorrow. That would be retroactive. Different things that can happen. But people, even if you, here's the thing, right? I've heard what people say, well, she need to go tell the truth and things of that nature. Just say you didn't tell, no, the people didn't tell the truth on the stand. Okay? Here's the problem with that. Did the defense prove you ain't tell the truth? That's number one. And two, if there was evidence to support what you said, you have a problem. You trying to backtrack or whatever, that ain't gonna help nobody. If you got second thoughts or whatever about what you said or whatever, you told a lie, that ain't gonna work out. That usually applies when like somebody like in death, like somebody was convicted of murder, that really murdered a person, somebody comes to confess, and you've seen in some cases even with the people confess, that prosecutor has evidence that proves that whoever they got behind bars did it. That's what they're going to go with, because that's when you're dealing with statements and the admissibility of statements and things of that nature. Now, if you really, I want to talk about some crazy shit. Sometimes some of the statements are considered, well, prosecutor will really argue this. Like if they have somebody that states that they killed the person or whatever, then that can be considered admission against interest. That means that the person making a statement places themselves in legal jeopardy, you know, and they wouldn't have had said that unless what they were saying was the truth. But we can way in the weeds. That's way down in law school. You start talking about that. That's way, well, depending on what school you go to. But yeah, so it's a lot. It's a lot. Um, I can tell you like the most common defenses, if not just about all of them, is innocence. Right now, you can plead innocent. You can have a defense that suggests that you are innocent. But here's the thing with that. But that means that the case against you is mainly circumstantial, and all you got is testimony and maybe some flimsy evidence. And like if it's saying you were there at the scene of the crime, um you got proof that you were at work, and you got people that can say you wasn't there and whatever, then a defense of innocence is appropriate, not to be confused with a plea of innocence. Of course, you're gonna plea not guilty, Lord. Of course, you can plea, that you're innocent of the crime, but I'm talking about the defense of it. It's different. You can go insanity, all right, which means that that's more than you saying that you were. They're saying that you were temporary and insane, or you got mental health issues. No, insane, that means you real crazy. You crazy to 25th power, and you can't be. And they'll put you in one of them, crazy jails and shit. A violation of your constitutional rights. You know what that means? Violation of due process and all of what the law guarantees you when you are being accused of a crime. You got defense of others. You have self defense. You have that. You have abandonment and withdrawal, meaning like sometimes, right? Just say you're going to commit a murder. Sometimes you break extra laws before you even break the law of murder, right? But just say at some point you you broke the laws prior to murder somebody, but you didn't break the law of murder. So you withdrew. You abandoned the murder plot. That's just a loose example. You were coerced or under duress, right? Now we're getting into the exculpatory defenses, right? One I tell you that justifies or excuses, right? Coerced and duress. But here's the thing. Boy, y'all say, yeah, that he was coerced or did it under duress. Here's the thing. When it comes to that sex under, with a minor, and I showed y'all on Nikki's website, the principles of surrounding that is that you are supposed to have a reasonable expectation that you're dealing with a minor when you're an adult. So if they tricked you into it, they say it's your fault because your ass should have known that you were dealing with a minor. So whether they showed you fake ID, whatever. Now I keep saying I never will agree with nobody being tricked into a crime. That is crazy to me. To me, that is contradicts the law because you wanna say um for the elements for to be proven of a conviction, you want to say mens rea and actus rea needs to be present at the same time, as well as not causation don't need to be there, but in causation, causation needs to be there as well. So you need mens rea, actus reus, and causation. But mens rea and actus reus needs to be present at the time of the crime. But if I'm being tricked into it, then how can the mens rea, my mind state, my mental, my actus reus, you're the one causing that because you're directly related to my behavior, which is the crime, because you're tricking me. I don't know I'm committing a crime and shit. And the causation, you're gonna trick me in that too. That's the cause and effect, the cause of the crime and the effect of it. I can't understand that. I can't understand why they can't come up with something when it comes to um violations like that. Like with the, I don't know why it's not a buffer or a workaround or something when it comes to that. That is crazy. You can't trick nobody into a crime. I can sometimes see that when it comes to selling drugs. Suppose I don't want to sell crack to you on that day. Maybe I don't feel like it. Maybe I feel like you 5-0. Maybe I feel like you the police. I don't want to sell it. Shit. And you keep pressing, man. I know you got it, man. I know you got it. Give me some of that hard. Give me some of that white girl. Give me some of that things for my big veins. Give me, give me, give me. And then I done sold you the, I'm like, okay. But maybe I done put my stash up at the stash house and I don't feel like going back over there. And here you come when I'm closing. Shit. Maybe that. And um then you have, the entrapment and shit like that. So yeah, so you have shit like that. So those are mainly the defenses, right, that you use in court. And so you can think, you can ask yourself which one of those would have applied to R. Kelly. Which defense should he have used, or which defense did they use? And we already know the outcome. So this is just not, this particular case is just not a lot of leeway in it because it required for him to be directly connected to the crime with like almost without a question almost. You understand what I'm saying? Like with the herpes. I know somebody else said he don't have it, somebody else, whatever. Oh, he got it now. Because all them people that done got on the stands or game came on the surviving say they got it. So, you know, he allegedly have. I'm gonna use just a regular girl that was of age or whatever. One of them girls that was of age. He done had allegedly had sex with her, and by now he allegedly have the herpes, and the girl end up having herpes. You can directly relate those herpes to him. Um, the videos. If he is in the video, that piece of evidence is directly related to him. So it's not even a too many. It didn't leave a whole lot of room to give an alternative explanation of how the evidence may have been produced, may have come about, may have been created. You know what I'm saying? Now when they see you in the video, unless you challenging the authenticity of it, I don't know if that was done rigorously or whatever. I don't know about New York. I think they kind of, yeah, they try to challenge the requirements. Remember, or the what the because I think it was I'm trying to remember that damn motion where they were saying that the they should have the prosecutor should have used the evidence, the videotapes that was used back from the 2008 trial, since whatever their reasoning for that. And then the prosecutor is saying that y'all understand stood the law wrong or the elements wrong or something like that. Remember they kept going back and forth, and it was the white guy's attorney that was really hammering them on that, with regards to that. So yeah. But other than that, this is kind of hard. I know everything comes up, seem like it's a smoking gun, it's gonna work, whatever, blah 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 blah. It's that you have to take that piece of evidence or whatever you got going on or your theory down a checklist. And if you can get, shit. But if it checks off the boxes with what the government had to prove, the elements and the facts of the case, like it's not, you know, it's not in the but the one thing that you have is that you have an experienced appellate attorney on the job and experience. She's gonna find some type of loophole. She's gonna argue them. She's gonna find them and she's going to argue them. So that's why I always told y'all from giddy up. Is the lawyers arguing that point? If is the lawyer saying this, saying that, whatever, then if they're saying it, then shit, I repeat after them. But if they talking about something over here, and you talking about something over there, and they have the files and they have the experience, shit, I don't know what you talking about. So, but I would pay good money if I could, boy, hear the conversations they be having. The client, attorney, client conversation they be having. I know, it's good. Ooh, it's good. Because he probably trying to tell one thing, and she probably trying to say something else, and shit. And he gonna win because he the what? Client. Misuse of the law. Mm-hmm. Yep, classical chorus. Yep. um. Oh man, I wish I could remember all those little warm up songs. Drum, drum, come here to tune. Sound of the cymbal, ching, ching, chong. Out of tune, Calliope's piping highest. Thrills like the winning of the horses running through the sky. Round and round the carousel is going. What do you like when I hear the rhythm of drum? Drum, I think I gotta come here to. And we used to sing it over and over and over again. We're like, oh my gosh, to warm, to warm you up or whatever we was doing. I don't know. I forgot. My God, damn. Round and round the Calliope. What do you like? Hear the rhythm of drum, drum. Come here, drum, December. Ching, ching, chong. Out of tune, Calliope's pipe. Yeah, them got him for acting silly. Um, so if anybody got it, anybody understand, I don't make sure you get it. Now get what she is trying, what she's going for. And she is going for the areas in the case where she think that there's a win. So it's not nothing for just for exercise or whatever. She's going for where she think that there is a win. Okay? But not to say it's going to be a win, but just saying I believe she has confidence in the things that she says it's going to be a win. You never know. It can be result in a reduction in sentencing. It can result in different things, or he can get retried and it can be more. He can be granted a new trial and can't get retried because of double jeopardy. You know? That would be interesting because that yeah, because of what I remember I looked, and so there is to fit what he was to fit his elements and his facts and stuff. Sexual exploitation was the only charge in that code. If I'm not mistaken, sexual exploitation can cover the herpes thing, cover the child production of child pornography, whatever they got it in as. It can cover domestic violence, him yelling and whatever, this, that, and the third. Remember, I told you, you can put domestic violence inside of sexual sexual abuse or exploitation, but you can't put that in domestic violence. So they would have to find different charges. Well, you don't charge them with everything. You done did duplication. And if it's when it's certain prosecutorial misconduct, they can't even retry based on what the prosecutorial misconduct was. So Anything can happen. But it's probably going to come down to some type of violation. I don't think at this point evidence is going to be the key, because I told you what the different rule procedures when it comes to appeals and evidence and new evidence, whatever. You know. But anyway, y'all, I'm finna get off here and decide if I'm gonna drag my ass up in the people's place tomorrow. God knows how I wanna go. Mm-mm. But but let me look at this system one more time. See if there's anything in there. Hold on, let me look. I'm trying to check the system. Yep, that's it. That is it. That bill right there gonna be whoa. I ain't gonna click on it no more. Shit. Anyway, folks, let me go. I sure appreciate y'all for this almost 4 hours. I guess I will see y'all over there with the Don Russell saga. Mm, mm. I can't believe that. Child, just when you think you understand one thing, something else hit you with this shit in here. You be like, huh? Well, where the hell this is coming from? And I actually believe that he is upset because he is not, like, R. Kelly ain't calling him. He ain't talking to him. He's not mentioning his name. He's not blah, 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 this, that, and the third. And I don't know. The last time I saw him on Texas Back Down channel, where he would say a little something, whatever, and I never forget. I was talking to somebody. I said, well, he said this and he said that. It wasn't nothing like he's saying now, but he was saying something like, he went to the pep rally and it was a plan to do this. Well, here's the thing, right? If you down by law and this, that, and the third, whatever, you don't say nothing. You don't know about no pep rally. You don't know nothing about none of it. You ain't got nothing to say. I was like, well, why he saying this? Why he saying that? So I was like, I don't know what to say. I never thought it would lead to this shit. But I was like, well, maybe he's just being honest with about certain things, that's not legally binding. But what is that to tell? I wouldn't tell none of that. I know nothing about what you're talking about. And I'm definitely going to be on no live talking about nothing of the sort. Shit. Mm. So, and I was like, I don't know. But anyway, y'all, it has been real. I see y'all whenever the next part come on. Make sure y'all like, share, and subscribe to Early and Till, child. Hey, I was sitting up there on Instagram waiting for the shit to come up. And somebody said, no, they got a goddamn YouTube channel. I was like, oh shit, this is on YouTube. I almost missed it because I was waiting on Instagram. My dumb ass. Well, anyway, y'all. All right, well, thank you, y'all. Let me see some more, y'all. Thank you, Classic Private, Nisa Mo, Stephanie Holloway, Respect Me, Parker Gang, 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 Evie Wild Wild, that's Donovan. Who else? I know JoJo was in here. Karen Johnson, I know was in here. Atmos Love. Purple, thank you always. Hey, DJ Amazing. Peace and love. Who else? Trevor Campbell. Oh, thank you, Trevor Campbell. Thank you, Punky. Oh, Jamaica loves me. Oh, thank you. Ooh, let me put that up. He said Jamaica loves me. Yes. I need oh, thank you, Pumpkin. Oh, that's so sweet. I like sweet people. Shout Tay, Jason Finch. Sonya Davis, P. Misconduct. Next Level, New Black. Queen E. Who else? Elvira Ward. Linda Alexander. JoJo, keep speaking whatever name you're in here under. Shaniqua Townbid, Sir Miguel. And I think I got the rest of y'all. Anyway. Thank you, Karen J. I sure appreciate y'all. Y'all. Courtney Love, James Harris, Cookie, Chanel Lewis, Danny, Karen Johnson, Lady Tech Queen Bria. Okay. That being said, good morning or good night, wherever you are. Peace out.